It is beyond that that the limitation of constituencies preceding the 2000.
After the much-awaited ruling envisaged to settle the hullabaloo that has been the delimitation of boundaries, debate is now shifting to just how binding it will be, at least as far as some of the lawyers who had challenged the process are concerned.
That depends on my clients.
We have to examine those decisions and consider the options.
While the lawyers argue that an appeal is a natural part of any judicial process, the other school of thought relies heavily on the Elections Act that has not provided for an appeal, an indication that this emanates from an election which is time-bound. The Elections Act says a person may apply to the High Court for review on the decision of the Independent Electoral and Boundaries Commission, and such petitions on the review of the boundaries to be had and determined within 3 months. Such is what culminated today. Article 89, subsection 11 of the Constitution also gives the 90-day period for hearing of petitions. But the lawyers argue with the same Constitution, citing a basic principle in law found in Article 164(3), which says the Court of Appeal has jurisdiction to hear appeals from the High Court or any other court or tribunal as prescribed by an Act of Parliament.
We can only ask for this decision to be appealed if we ask for a stay on preparation of the elections. That is something that we have to think about very carefully. So, but I think IEBC have got the message that they have to be careful.
It remains to be seen then if indeed any aggrieved party will lodge an appeal and whether it will be accepted. But most significantly, an appeal or no appeal, whether the Independent Electoral and Boundaries Commission's calendar will be affected in any way. Hussein Mohamed, Citizen Live at 9.